Hi everyone, my name is Ramit Mizrahi and I am an employment lawyer here in Pasadena, California. I'm really excited to speak with all of you today and to cover issues with respect to returning to work safely in this COVID era. Um, Before I get started, I'm going to tell you a little bit about myself. So my practice has focused since I graduated from Yale Law School about 15 years ago, exclusively on representing workers. I focus on discrimination, harassment, retaliation, and wrongful termination cases. I often help people who are trying to deal with situations where they need medical leaves or other situations, accommodations in the workplace, and making sure that their company navigates things correctly with them. So right now, many of you have been working remotely or have had situations where your workplace has been closed and you've been outside of the workplace for some time. But you understand that your employers are gearing up and planning a return to the workplace. And with that come concerns about how you can do that safely, particularly if you're considered someone in a high-risk group, whether it's being over the age of 60, having other medical conditions that have been deemed to be high risk in terms of COVID symptoms and consequences, and figuring out, well, what can I do? And so I have the opportunity to speak with you about that. And I'll cover some of the legal protections that are available to you because we have some really excellent discrimination and disability accommodation laws and leave laws out there. But if you don't know what your rights are, then those laws don't actually benefit you. So before I jump in, I want to tell you the disability accommodation laws in particular are very, very fact specific because there is a discussion with respect to the fact that employers have to give you certain accommodations that are deemed reasonable unless it would create an undue hardship for the business. And what may be appropriate for a person in one kind of job in one kind of a company may not be appropriate for a different person working for either a different kind of company or in a different sort of role. And so my purpose here is to give you general information to let you know about the sorts of laws that exist. But as you navigate your specific situation, it really would be helpful if you come up with challenges to consult with a lawyer or to seek help from a legal aid organization or what have you. In addition to accommodation matters being very fact specific, some of these laws that I cover have some magic numbers in that some laws don't apply to certain employers, right? So for example, 5 is a magic number for disability accommodation, 15 under federal law, 50 for the Family and Medical Leave Act and our California Family Rights Act, 500 for the FFCRA, the Families First Coronavirus Relief Act. So I may be covering some laws that if you're not working for a large enough employer or if you work for an employer that's too large, may not necessarily apply. But I'm at least giving you an idea of what's out there and available to you, and you can kind of delve in and figure out what applies. So as you all know, and I want to add, I am a California lawyer who focuses primarily on California law. So to the extent that some of you folks are outside of California, definitely look into whether you have state protections that may supplement some of the federal protections that are available there, and dig into that. Also, some of you may work in unionized workplaces and you may have greater or additional protections in addition to anything that I cover here today. So as you know, here in California, Governor Newsom passed an executive order that essentially ordered people to shelter at home, except as needed work-wise for businesses and employees of certain critical infrastructure sectors, right? So food, transportation, energy sectors, financial sectors, those are certain workplaces where people have continued to work. Even in those workplaces, if that work could be done safely, people were still encouraged and expected to work remotely. slowly these restrictions are being eased, but even at sort of the peak of the restrictions, statistics are that over half of people fell in jobs where they worked for critical infrastructure sectors and were still expected to continue working despite the shelter-at-home orders. In addition, I want to note that other states and local governments have passed their own orders. So this has been a remarkable time in terms of so many different laws and ordinances and orders that apply, both in terms of requirements and restrictions for businesses in terms of their functioning, and also in terms of the different protections that apply for people. Now, some of the laws that I touch upon have been around for a long time, and I'm going to use a lot of acronyms, but I'm going to do my best, because I know you folks are not lawyers, to spell out the laws and explain them. But some have been around for a long time, like the Americans with Disabilities Act, the ADA, or here in California, our Fair Employment and Housing Act, FEHA. And I probably won't be able to resist calling it the FEHA, because that's what we lawyers call it. But we also have some new laws, like the FFCRA, Families First Coronavirus Relief Act, and the CARES Act, that were brought in to add additional protections and benefits to working people. So with that, let me jump in a little bit and cover some of the questions that we've seen and some of the protections. So the main focus here today is really return to work issues, and if not possible, then what leave rights do you have if you can't? So the first question and sort of theme is, what are my options if my workplace opens up and my doctor doesn't believe that it's safe for me to return to the workplace, right? Can I ask to work remotely? What if my work can't be done remotely? What if my employer resists? And so first and foremost, it's important to know that there are disability accommodation protections. Here in California, if you work for an employer with 5 or more employees, and under federal law, 15 or more employees, the employer has an obligation to provide reasonable accommodations to a person with a disability who needs those accommodations to be able to perform their job. Now, you're entitled to those accommodations so long as you're qualified for the job and can perform its essential functions, so long as the accommodation is reasonable, right, just sort of on its face reasonable, and so long as the accommodation is not one that would create an undue burden or an undue hardship for the employer, right? So basically, if you ask for a reasonable accommodation supported by, medical documentation, medical support, the employer is required to give it to you unless they can show that it would create an undue hardship for them. And in the law, there are some guidelines for what would create an undue hardship, looking at factors like the nature and cost of the accommodation, the overall financial resources of the entity, the types of operations, and other sorts of factors that are analyzed. But there are a number of accommodations that in time have been recognized as being reasonable. So for example, working remotely would be deemed a reasonable accommodation. In having an accommodation discussion, I want to note that if there are multiple options that let you effectively do your job safely, the employer can pick among them, right, if they're all equally effective and equally safe. But in terms of accommodations, leave is essentially a last resort, right? Because if there is an accommodation that allows you to continue working and continue doing your job, that should be the first option. Other accommodations include being able to work remotely, as I said, working an alternative schedule. For example, if there's a workplace where most people are physically there in the mornings or afternoons, maybe evening shift or weekend shift, something like that. Or if you have to pick up the mail coming in early in the morning or late in the day. Asking for changes to your workplace setting. For example, if there's a cubicle situation where there are a lot of people moving around, maybe asking for an office with a door, getting additional PPE, things like that, right? In looking at accommodations, it's really for you, the employee, to consult with your doctor to get a sense of what it is you need to be able to continue doing the job safely, and then having a dialogue with your employer about that. For a lot of folks, I think working remotely is probably going to be their first choice because they feel most safe in their homes, right? And there are a large number of jobs that can be done remotely. I think the statistic I saw was somewhere around 40% of people have been able to continue working remotely. And I think that if you have done that for the last couple of months safely, it will probably be challenging for an employer to say that that's not a reasonable accommodation. Because if you've been able to do your job, why, just because they're now back in the office, doesn't undermine the fact that you can do it and have been doing it remotely. There are some jobs where that may not be an option, right? And that's where I think the discussion becomes a little bit more challenging. In terms of remote work, some employers may want you to be in the office. That, to me, is generally not enough reason to deny you the request to work remotely, particularly if your healthcare provider, your doctor thinks that is what you need to be safe. Other options can include, for example, transfer to a vacant position for which you're qualified if there's something available out there. They don't have to create a position for you, but if there is a vacancy in a role that you're qualified for and can do, that is something that is also considered. And like I said, there may be certain jobs where it's just not an option, and continued leave is really the only option. So let me jump into leave rights a little bit. So there are two sort of elements to leave rights and to leave laws. There's the aspect of it that involves job protection, and by that I mean that you can't be fired for having taken that time off. Certain laws provide that. And then there's wage replacement, right? Will you get compensated for the time where you're not able to actually work and you're out on a leave? So let me run through some of the laws. First, there's a paid sick leave law in California, and it's the Healthy Workplaces, Healthy Families Act. And so in California, if you've been at a job for a minimum of 3 months, you are entitled to take, I think it's up to 3 days a year that the employers are required to give you. There are some details in terms of how that time accrues, but that's sort of the sort of small amount of time that is sort of, you have it at a minimum. Certain cities have provided for more paid sick leave, including, for example, Los Angeles, San Francisco, Santa Monica, the list goes on. In addition to that, you have the big leave law, and the one that's sort of a household word is the FMLA, right, the Family Medical Leave Act. Here in California, we have our California version of it, the California Family Rights Act, CFRA. And I can say I've never filed an FMLA case because the CFRA gives you the protections you can get under the FMLA. And like I said, generally, California state laws offer excellent protection. So I will say CFRA, but I may intersperse it with FMLA. So that law, those laws, apply to employees who work for either certain public entities or private employers where there are 50 or more employees within 75 miles of where the employee works, and the employee has certain eligibility requirements. They have to have worked for the employer for at least a year. They have to have worked at least 1,250 hours. And again, they have to have at least 50 other employees within 75 miles of them. Now, once that eligibility criteria is met, the employees are entitled to take up to 12 weeks a year of job protected time off for either their own serious health condition, for care of a child, parent, spouse, registered domestic partner with their own serious health condition, or for baby bonding time, which is not really applicable here. So it's focusing on leave for their own serious health condition. If you're in a situation where your doctor doesn't think it's safe for you to continue working under the conditions that your employer is offering you, FMLA, CFRA leave comes into play, and you have that 12-week entitlement. Now, as I said, that time is generally unpaid, but there may be other wage replacement opportunities that I'll cover in a moment. In addition, we have the new law, the FFCRA, which is expanded emergency paid sick leave and emergency family care leave. So the FFCRA is a little bit quirky because while the FMLA CFRA covers employers with 50 plus, FFCRA covers employers with up to 500 employees, which I tried to wrap my mind around that and figure out why would you have a law that exempts these large employers. And my takeaway is that FFCRA's emergency family care leave and paid sick leave are paid, and they're paid, essentially the employer pays you, and then they get a dollar for dollar tax credit up to a certain number. So that's probably why this turned out that way. But under the FFCRA, under the FFCRA, you're entitled to take leave if you are, it's up to 2 weeks of paid leave if you are sick, and it's if you're subject to a federal, state, or local quarantine or isolation order related to COVID-19, if you've been advised by a healthcare provider to self-quarantine related to COVID-19, and I would read that to include someone who's self-quarantining because they're at risk, not necessarily because they have COVID. If you're experiencing COVID symptoms or caring for an individual who's either subject to one of the quarantine or isolation orders or has themselves been advised to self-quarantine, or caring for a child whose school or place of care is closed, or experiencing any other substantially similar condition as the federal government will define. So that those 2 weeks, you get paid at your regular rate of pay, up to about $511 per day, or a total of $5,110. And in addition to that, and if you're caring for someone else, so the regular rate of pay is if it's for yourself. If you're taking that time off to care for someone else, it's at 2/3 of your regular rate of pay, up to $200 a day. On top of that, there's another 10 weeks that you can take, which is for paid extended family and medical leave, where you get paid at 2/3 your rate of pay, but that's if it's to care for a child who has their school or child care provider closed. So not necessarily applicable here, but useful to know. And in the end, I'm going to share some resources to the Department of Labor's website and some California government websites and some nonprofit websites where you can get some information. So I know that this is a lot of information quickly, but just to kind of give you a sense of your leave rights. Now, those laws are sort of bright line laws, bright line rules. And by that I mean that you can calculate exactly how much time you're entitled to, right? If you're entitled to CFRA or FMLA leave, you say, okay, I get 12 weeks. I used up 2 weeks, I have 10 weeks left. When you're talking about disability accommodations under the Fair Employment and Housing Act, FEHA, or the ADA, it's a different standard. So as I said, FEHA accommodation obligations are triggered for employers with 5 or more employees, and it's 15 under federal law for the ADA. And I've also not had to file an ADA claim because I file them under California law and under the FEHA when there's a disability accommodation issue at play. So under the FEHA, you are entitled to leave as a reasonable accommodation for a disability, and there's no magical number, meaning that you may need 2 weeks and that may be reasonable, There are some cases that have found leaves of many, many months, even, for example, 6 months, where the court deemed that that would have been an appropriate accommodation. So there's no fixed amount of time that's automatically deemed to be excessive. However, the law says that employers are not required to give indefinite leave, meaning a leave with no known end date. Because the idea behind giving a medical leave as an accommodation for an employee with a disability is that it's giving you time off so that you're able to come back at some later point in time. And so if there's a doctor's note that just says return unknown, it can be argued that, well, if you don't know if you can ever return to work, how is that a reasonable accommodation? Now, approximate return to work dates are not considered indefinite, meaning if your doctor puts a note and says, return to work anticipated September 1st, 2020, or, to be reevaluated or something like that, I would argue that's not indefinite. And revised return dates, right? If your doctor puts you out for a month and then extends it another month and may even extend it a third, I also say that's not an indefinite leave because there is a date certain, it just got moved a couple of times. In determining whether to grant an employee a medical leave as a reasonable accommodation, it really is an individualized assessment. And that is where you look at factors like, how much of a hardship is it to have that person missing? Can you hold their position open? Are there other people that can fill in? So, for example, if someone has critical and unique knowledge and the employer says, hey, if you're out for 4 months, we don't know how we're going to get this working, that may be different from someone in a situation where, for example, a bank teller, where, they can bring a temp bank teller to fill in, right? It's not going to be a hardship for that employer to allow the employee some time off, assuming that there's a reasonable period of time. When you take leave as a reasonable accommodation, and also under these other leave laws, you're entitled to return to the same or an equivalent position. When it's leave as a reasonable accommodation, you're entitled to return to the same position unless it would be a hardship, and comparable position, again, unless it would be a hardship. You're not guaranteed your job forever. Meaning that if the employer is conducting layoffs and they're letting go a bunch of people and you would have been let go anyway, they don't have to keep your position and your position alone open because you were out on a leave. Take a sip. But you can't be penalized or selected for layoff because you're a person who took a leave. So how do you ask for the leave? What do you do? What documents do you need to give? It's important to note that in California, you do not need to disclose your diagnosis when you're asking for a leave, either as a disability accommodation or under the leave laws. You just need to let the employer know under CFRA FMLA that you have a serious medical condition, under the disability accommodation laws that you have a disability, and that you need the leave, and give them an anticipated duration and let them know. Technically, you don't have to request the leave in writing, meaning, for example, if someone tells their supervisor, I need a leave, that should be enough to put the employer on notice, but it is absolutely a best practice to put it in writing so that there's no dispute that you asked for the leave, what you asked for, and so on. Now, it's helpful to get a doctor's note, and again, a lot of doctors put your diagnosis in there. They don't need to. It's really a personal decision for the employee with respect to whether or not they want to share their diagnosis. Some people find that maybe the employer may be a little more sympathetic or understanding if they know what the condition is, but sometimes people are nervous that they'll be discriminated against, and there's really no right answer. I can tell you that the law doesn't require disclosure of the diagnosis, and you have to make a personal decision in terms of what you think will be best received in terms of your request for accommodations, whether you ask for the first time or on an ongoing basis. Now, when you make the request, if it's a request for leave under CFRA and FMLA, the Family Medical Leave Act, the employer may give you paperwork, a medical certification for your doctor or healthcare provider to fill out. They can do that. I will note that the paperwork in California is different from the Department of Labor paperwork. The federal paperwork can ask for diagnosis. The state paperwork doesn't, so just be mindful of that. With respect to, again, requests for accommodations in the workplace, including whether it's leave or being able to work remotely or what have you, as soon as you put your employer on notice that you need a reasonable accommodation, they have an obligation to engage in what's called the interactive process. And the interactive process is a term, I think of it as like a dance, right? You ask for something, they either give it to you or they, kind of have further discussion and kind of counter back, and you go back and forth until a suitable accommodation can be found. If one side or the other drops the ball, the law deems them responsible, right? So if an employee asks for an accommodation and the employer just flat out rejects it without any analysis, without any discussion, they're held legally liable for breaking the law and not giving an accommodation that the employee was entitled to. On the flip side, if the employee asks for an accommodation, the employer comes back and may ask for some follow-up information, etc., and the employee doesn't engage in the process and turn over that information, then the employee is deemed to have sort of dropped the ball, and they may not be able to win on their claim. The guidance that I would give you all is, if you ask for an accommodation and it's granted to you, great, you're good. If you ask for an accommodation and the interactive process, you go back and forth and you get what you need, still good. If the employer resists, or they ask you for your diagnosis, or they ask you to sign a release for medical information that is intrusive, or they don't get it, right at that point, it probably makes sense to seek the advice of an attorney or to seek help from the government. The California Department of Fair Employment and Housing may also be able to help people, although they are of limited resources. So I think if you can consult with a private attorney or a legal aid organization, I would probably encourage doing that first, but it's up to you. What if you can't get a doctor's note or a medical confirmation? In these times of COVID, it may be hard to book an appointment, or you may not want to go in person for an appointment. My recommendation is try. You don't necessarily have to go in person. There are a lot of telemedicine appointments these days. And having that doctor's note in hand to give to your employer goes a very long way. If you have a doctor's note that says, due to disability, recommended that employee work remotely, for the next 3 months as a reasonable accommodation, that is really powerful, as opposed to just saying to your employer, hey, I'm worried, right? Can I please work from home? The doctor's note goes a really long way. So absolutely try. At the same time, if you can't get an appointment, you can't get a note, I would let the employer know that. I would say, I've been trying really hard to get an appointment. My doctor can't fit me in until 2 weeks from now, or something that again shows that you're making the effort, so that the employer doesn't shut the door on you. Also, I know that even the Department of Fair Employment and Housing, so that's our version of the EEOC, the Equal Employment Opportunity Commission, has made note that employers should be understanding about the fact that people may have challenges getting notes, right? So even there's even government guidance that employers should be mindful that these are challenging times and it may be hard to get that information, but nevertheless try. So what happens if you can't return to work? Will your leave be paid? How much and for how long? So covering some of your paid your wage replacement options. As I said, there's the 2 weeks under the Families First Coronavirus Relief Act, the FFCRA. CFRA, FMLA, and leave as a reasonable accommodation are all unpaid, but you may be able to use your accrued sick pay. You may be able to use your accrued PTO. In addition, there is state disability insurance, SDI, where you can apply if you're out on a medical leave for that wage replacement through the government. And some employees have short-term disability and long-term disability plans, so definitely look into that to see if that's an option that's available to you. Now, for some of you folks who yourselves may not have a disability but may live with someone who does, and who's immunocompromised, where it's not recommended for you to go to the workplace because you're worried about bringing infection home to your household, This is one of those situations where there's a bit of a gray area and it varies based on state. There was a 2016 California Court of Appeal case that suggested that employers may need to provide accommodations for those who are associated with a person with a disability. And so again, some of that analysis that I discussed earlier may apply. But again, as I said, there's a little bit of a gray area here, so you have to tread carefully. But I would certainly put the employer on notice, I'm in a household with someone who's immunocompromised. Can I please continue working remotely? Or may I please have a leave for another month or something along those lines? Now, if you take a paid sick leave or family care leave, what happens to your health insurance? So under the FMLA, Family Medical Leave Act, the CFRA, California Family Rights Act, and the FFCRA, the employer has to continue your health insurance on the same terms as if you were still working. So if you had some copay or some employee contribution, it would continue at that level. Once you've exhausted that leave right and you're on a ADA FEHA disability leave, you have the right to continue your insurance, but you may have to pay for it, right? It's sort of COBRA rights. And so you may have to pay for your insurance at that time. Once you separate from your employer, for example, if you're laid off or you can't work and they let you go, at that point, again, you have COBRA rights if you had a group insurance plan, but you may be eligible to apply for Covered California during, an eligibility period, right, where there's been a triggering event where you may be allowed to reapply and get insurance through Covered California. Now, if you've already taken leave under the California Family Rights Act, under the FMLA, we'll just say specifically the FMLA, that may cut into some of the time that you have available under the FFCRA, so just be mindful of that. So those were my, some of the questions we got earlier. There are a couple more that I want to jump into that you folks submitted over the last week or so. There were a couple people who really expressed concern about the fact that their employers were not abiding by CDC guidelines, where people were not wearing masks even though it was recommended. People are not keeping social distance. People are kind of doing things that are not recommended, where employees are feeling that their safety is jeopardized. And someone asked, what do I do if my employer is not abiding by those guidelines, but I don't have a doctor's note telling me that I have to work remotely? So I would say, if an employer is not following guidelines set out by the California Department of Public Health, the CDC, where it's not safe for you to work, speak up, right? And again, I think you have to make a decision with your doctor of, if they comply, is it safe, right? And if so, you may need to speak with your employer and say, look, I'm seeing that employees are not complying. I don't feel safe. Please take these steps to protect me. And if you're subjected to retaliation, you may have whistleblower protections on top of all of these other rights that I talked about. And again, you may need to decide whether remote work is an option or if there are other accommodations that would allow you to feel safe and that your doctor thinks is safe for you. Another person said, again, their employer doesn't take these COVID risks seriously. If they need to quit their job due to feeling unsafe, what happens then? Can they keep their insurance? Can they get unemployment? So again, I see two issues there. One is, can you quit? I would be careful and not quit a job before consulting with a lawyer, because you may have a legal claim. There's a legal theory called constructive discharge that the law recognizes, or wrongful constructive termination in violation of public policy, which is, if your working conditions were so egregious that a reasonable person in your position would have quit. For example, if you have a supervisor that's constantly sexually harassing you, or you're working in an environment where the company is engaging in unsafe and hazardous practices, or they're asking you to violate the law, or they're not paying you minimum wage, right? If there's certain circumstances where a reasonable person would say, you should quit, it's not safe for you, you may have a lawsuit against the employer under those circumstances. But I would always say be careful before walking away from a job, because if you do it the wrong way, you may lose certain legal protections and legal rights. That being said, in terms of unemployment and unemployment insurance, you're not expected to endanger your health. You're not expected to do something that is in violation of what your doctor tells you is safe. And so, be mindful of that. There are protections out there, as I've talked about, and there are all sorts of workplace guidelines in terms of how workplaces are supposed to be to keep employees safe. And this is, like I said, the California Department of Public Health, the CDC, LA County has its guidelines and ordinances. In terms of health insurance, as I said, that's when your COBRA protections and CalCOBRA protections kick in. Another person asked, if I'm laid off during COVID-19, can I receive both unemployment and apply for disability? So with the caveat that I'm not a disability specialist, and by that I mean I help people with workplace disability issues, not so much with the government side. You will have a speaker who's focusing on disability issues in a few weeks. But I can tell you that generally you get one at a time. And so if you are laid off, you're entitled to unemployment insurance. Unemployment insurance, just to give you an idea, generally it's up to $450 a week. It's somewhere around 50% wage replacement. But because of the CARES Act, the federal government is adding an additional $600 a week on top of that through July 31st. So you, depending on what you're paid, may actually end up receiving more from unemployment during this window of time than from working. I've heard different numbers, but somewhere around 20, the low 20s an hour, you may actually end up better off on unemployment. And that unemployment typically lasts for 26 weeks, but it's been extended to 39 weeks. State disability insurance is up to 52 weeks. So also bear in mind that, we have the highest unemployment rates now since the Great Depression. And it may be hard if you lose your job to find another one. And so it may not hurt to leave the SDI as an option once you exhaust your unemployment. But again, this is not my area of expertise. This is just, think through these options as you navigate the system. Another person asked about a situation where they have a part-time job teaching, and they said, I can't go back to work due to the outbreak, and what are my rights for payment if I can't return to work when they want me to, right? So again, this is a situation where you're looking at the interplay between unemployment insurance and potentially disability insurance. If you're unemployed, right, you're not working because that workplace is not open, you are entitled to your unemployment insurance. Once that is exhausted, and if there's a situation where you still can't work, that's, I think, where you would look into disability insurance options. Someone else asked, when interviewing for a new job, do I have to disclose that I have lupus? Can I mention it later? And so I go back to saying, under California law, you never need to disclose your diagnosis, and you don't necessarily need to disclose that you have a disability unless and until you're asking for a reasonable accommodation, and then you can tell them. And so think through, what are the essential functions of the job? Can you do them? And if so, you can get into that dialogue with them once you've started. And the question of when to disclose, again, is a personal one, not a legal one. And by that I mean, I can tell you that you don't have to disclose, for example, your diagnosis. But it's also a question of how do you think you'll be best received? So for example, if you're applying for a new job and you're pregnant, do you disclose that? Well, if you do, you may not get hired because bias is rampant. But if you don't, and then, your first day of work, you say, by the way, I'm 5 months pregnant, that can be challenging too. And so you have to figure out, it is illegal to discriminate or retaliate against people in the workplace, but people do it anyway. How do you minimize the odds that things turn out badly for you? And so that's sort of in a sense, a non-answer to your question, because I can't tell you what specifically to do. I can only tell you what you have to or don't have to do, and then you kind of make that call. Finally, or I guess penultimately, there's 2 more questions I want to cover. A person said, I haven't been vaccinated since my diagnosis. How can I protect my job if I'm being asked to take a vaccine and I'm worried that it would potentially cause a flare-up and be lethal for me. So a lot of us are hopeful that in the next year or two we'll have a COVID vaccine that's effective. And one can then expect that certain workplaces are going to ask people to be vaccinated. For example, someone working in a healthcare setting, right? We know, for example, that in certain hospitals, people are expected to, all employees are expected to have flu shots. And this is yet another situation where the reasonable accommodation discussion comes in. So, for example, in hospitals where flu shots are required, there are often exceptions for those who have known allergies to vaccines, known severe allergies or are otherwise at risk. So that's a discussion to have in terms of an interactive process. And finally, I saw some questions about EDD benefits and issues with the calculations. A lot of people have had issues in terms of the calculations, whether it's the time period that was used for calculating things or even for gig workers, independent contractors, the self-employed, they're entitled to the $600 a week through the CARES Act, and yet some of them have been having challenges getting it. So I don't have specific advice other than the system is overwhelmed. It's been very challenging for people, and keep trying. So with that, that's the end of my remarks. If there's anything else, I'm happy to jump in briefly. Let's see, I'm scrolling through everyone's questions. Give me a moment. Okay, so there was a person who asked, they said, they were able to get their doctor to certify them to stay at home when the pandemic started, but the doctor doesn't want to do it anymore and the employee is slated to go back home. They asked for an accommodation that included allowing the person to have PPE, and they're having difficulties, and they've been having challenges with their doctor. So I think I covered this a little bit, but yeah, I mean, the hard part is you need to find a care provider or at least let your employer know that you're in that process. Because when a doctor, when they see the doctor said this is the accommodation you need, they recognize, okay, this is a disability, this is the requested accommodation. They may push back against you. At the same time, I will note you can also point them to certain guidelines. So for example, the California Department of Health had guidance for people who are high risk, right? And one of the things that they said was stay at home as much as possible. So I think you can try to find that language in the meantime. Someone asked about a possibility their employer may have them sign waivers that state that if they come back to work and get COVID, they can't sue. So right now, the California governor has essentially signed an order that said that if you're back at work and you get COVID within a certain period of time, for workers' comp purposes, there's a presumption that you got it at work. I would be very reticent to sign any kind of a waiver because, you have these protections in place, and, why would you waive them? And I think that a person who lost their job for refusing to sign something that gives up their legal rights, they may have a whistleblower claim. So I would be careful about that. I'm sure that these issues are going to shake out. I know that there's also some federal political discussions right now about certain immunity from employers, and we'll see how that shakes out also. And again, someone said they've exhausted their 12 weeks of FMLA and are hesitant to go back to work. Is there anything that they can do? Again, I would jump in and say this is where leave as a reasonable accommodation comes in, meaning that CFRA and FMLA may be completely exhausted, or for some people they never qualified for it because they don't work for a big enough employer. The reasonable accommodation analysis comes into play every time. And if your doctor says that you need as a reasonable accommodation for your safety, either a leave or certain other accommodations, that interactive process has to happen. I see a question about applying for short-term disability and whether future employers see that. I will defer those sorts of questions to the disability SDI government benefits expert. And Someone said they had the opposite problem. They were on reduced hour medical leave before the pandemic and working from home in quarantine. Let's see, they said that it improves their flare up and they wanted to be back full time, but the employer said they didn't have hours to give back anymore. So, couple of things. One, which I didn't say and I should say, is that your employer cannot decide for you and say, aha, you're over 60, I'm not going to let you work, or aha, you have a disability, I'm not going to let you work. So there are protections if things go in the other direction where you're being denied an opportunity to work because of your disability or because you're in a risk group. In addition, if the employer has reduced hours, furloughs, layoffs, you just have to be treated similarly to all of the other people who don't have a disability. In terms of if your hours were cut and you didn't get your full pay, you are entitled to apply for unemployment benefits for that period of time. And my understanding is that if you get even $1 of regular unemployment benefits through the EDD, that will be supplemented by the additional $600 a week in federal dollars under the CARES Act. So if your income is being cut for any reason, you should definitely look into the wage replacement options. And I think with that, I am done. Thank you everyone for your time. Again, I encourage you, if you have specific issues, to reach out to attorneys. My name is Ramit Mizrahi, Mizrahi. My website is MizrahiLaw.com, MizrahiLaw.com, MizrahiLaw.com. And if anyone has any particular issues, you're welcome to reach out to me. If I can't help you, I will try to give resources, and I will try to put in the comments some links to resources that may be helpful to you. So thank you all very much. It's been a joy.